Mr. Tolman, you may begin.
Thank you, Chairman Jordan, Ranking Member Raskin, and distinguished members of the committee. Thank you for the opportunity to testify today. Oversight of the Foreign Intelligence Surveillance Act is a debate that goes to the heart of what it means to be an American. Commitment to the rule of law, the constitutional rights we hold dear, and the principle of limited government. FISA is in desperate need of reforms, or rather, our country desperately needs to reform FISA. For decades, and with increasing regularity, it has been the government's permission slip for warrantless spying on Americans. This is despite the Fourth Amendment. To be sure, FISA serves an important national security interest. I would know I helped write some of the FISA laws when I worked as Chief Counsel over Crime and Terrorism in the Senate Judiciary Committee. I later prosecuted national security cases as a federal prosecutor. These credentials, however, don't contradict the harsh truth that the FISA system is flawed. It enables the unconstitutional government surveillance and doesn't protect our civil liberties presently. Nowhere is this more clear than with Section 702. Section 702 was sold to Congress as a vital tool to target foreign adversaries. We were given high-stake assurances by DOJ and FBI leaders, namely James Comey and Robert Mueller, that it would not be used improperly against honest Americans. I was in the room when they represented it would not be abused. That was a lie. FISA abuse is not speculative. There is clear record of systemic failure, constitutional betrayal, and the disregard for the rule of law, confirmed by the FISA court itself and government watchdogs. For instance, the Crossfire Hurricane investigation used flawed information and deceit to justify FISA's surveillance of Carter Page. Proves the vulnerability the system is to political weaponization. Arctic frost investigation, which targeted hundreds of American citizens, including sitting Republican lawmakers, highlights how domestic political matters are swept up by FISA. The FBI has carried out warrantless searches of Section 702 database involving American lawmakers, journalists, political donors, civil rights protesters. 1,600 searches were conducted for Americans who were at a specific airport on a particular day. 2,000 backdoor searches were done on athletes at a sporting event. NSA analysts searched for communications of prospective tenant and rental property that they owned personally, and for people met through online dating sites. This is not national security intelligence gathering, it is domestic spying. With FISA set for reauthorization in April, Congress faces an important question. Will we limit government or will we license its continued Fourth Amendment violations? Internal policy changes by the offending agencies are not enough. FISA must be rebuilt and reformed. Section 702, for example, it is necessary that Congress requires the government to obtain a probable cause warrant if a search is done on a U.S. citizen in a domestic investigation. If this warrant requirement had been in place, that vast domestic surveillance of Americans under Arctic frost, for example, would have required judicial review and likely would not have occurred. Section 704, which lets the government surveil Americans abroad believed to be a foreign asset, would benefit from heightened judicial review, such as declassified and released court opinions and the use of third-party experts who can review Section 704 applications. Section 705B can easily bypass the requirement for comprehensive judicial review, allowing the government to move to a more intrusive form of surveillance with less scrutiny than a new probable cause application would require. Reforms should center on the consistent probable cause decisions. Lastly, FISA courts need structural reforms, such as penalties for omissions or misrepresentations like those used to target Carter Page. The FISC should also incorporate third-party advocates to balance the weighted government proceeding and declassified FISC rulings. In conclusion, Congress must not be complicit in facilitating a surveillance state. It must either mandate reforms or allow authorities like Section 702 to expire. I applaud this committee and its leadership for its thoughtful review, and I stand ready to work with you to craft reforms that are conservative in principle, effective in practice, and constitutional in design. Thank you, Mr. Chairman.
If you were prosecuting a case, would you accept anything less from somebody who committed that crime, assuming you're not locking him up for years for doing it in the beginning?
No, absolutely not. But our history shows, for example, in the attorney Kevin Kleinsmith, that he was prosecuted for his misrepresentation to the FISC, but received no jail time. So is there meaningful deterrence? And presently there is not.
why, as a former prosecutor, you would say this really is a completely different matter, and that's comparing apples and oranges.
Yeah, I appreciate the question because I think we think of it wrong when we assess the use of extraordinary tools to gather intelligence in this country. We're not looking at it through the criminal justice system lens. We're looking at it through national security. And there's the mentality of national security review is that the Fourth Amendment does not apply. So once you cross that line, you no longer are concerned about whether or not you're following certain constitutional protections. And that should scare American citizens that we have people that will exercise that power who have crossed that line and are no longer thinking of it in terms of what they traditionally would as a prosecutor.
Others quickly.
I would quickly say where you stand on an issue depends on where you sit. I rarely had any supervisor that pushed back against any request I had to approach either the grand jury or a judge for a warrant. My conversation with a former Chief Justice of the FISC was his greatest concern was the fact that there was so much pressure to grant everything that was presented to them that they didn't have the ability to review it thoughtfully. Now they do. I would just lastly say, why aren't they capable of self-governing in this area? And we have to remember, post 9/11, we shifted the FBI and the Department of Justice's overarching mandate to intelligence gathering for national security purposes. So once you do that, their mentality is not to self-govern.
$12 billion we give to the FBI. That's their budget. Over half of it is used on the surveillance stuff. Versus, I mean, you go talk to average American, they would say like, what? I thought the FBI was supposed to be going after traditional bad guys, not spying on Americans. So you're exactly right. That is a problem. One last thing, and I know I'm a little over time. I'll give it a little more time to the next Democrat witness. Someone said, let it expire. I forget which of you said that in your opening, Mr. Tolman, the guy who helped put it together. Give me your thoughts on that.
Well, without wisdom, and in my youth, I bought everything that was, argued by the Department of Justice as to why they needed it. Then you see their incapability of actually governing themselves with such power. It would be like 215. We let that expire, and here we are still stopping national security threats.
Yeah.
We didn't think that was possible when 215 expired.
Yep.
The fact that it's so secret and it's contained exclusively within those that present to the FISC those powers, and we're really talking about internal powers of the FBI, without being able to shed light on what they're doing and who they're contracting with, it's very difficult to stop its use. And it will continue to be a challenge unless we are putting, for example, third parties capable of reviewing what they're searching and who they're contracting with. If we prevent and put guardrails on the scope of that contracting, we might be able to make an impact on its abuse. Where there's a deficiency in a warrant, Title I warrant, the FISC judge will actually go back to DOJ and ask them to fix or provide additional information on a deficient warrant. An amicus system would prevent that. The overarching concern I have is you have 1978, you have 1981 on 12333. We didn't have the ability to collect the data that we do today, nor the access to it. It was a very different government that we were talking about back then when those executive orders came out.
Is there any legitimate reason why we should not have the warrant protection included in a reform to FISA? Mr. Tolman.
No, and in fact, the reasons stated are illegitimate. You take the argument that the FBI can do it themselves. I've never believed in the Fox being able to analyze and control what the Fox does in the hen house.
What are they purchasing from data brokers, and what are they using it for?
Well, as you know, there's so much data that is collected that from outside the government that there's really no limit to what they can purchase that can be obtained through online use, through emails, through other data points, financial institutions. They're really, if you think about it, it could be in its worst form, the ability to collect everything that they can't collect under a warrant, without a warrant.
Very dangerous, I would assume.
Correct.
For personal privacy and certainly for our amendments to protect those privacies. You know, in 2023, the FBI admitted to buying precise geolocation data derived from mobile phone advertising. What should Congress do about this?
You know, I became aware of individuals, for example, that traveled to Washington, D.C. Were not traveling on January 6th to the rally, were not entering the Capitol. They simply were traveling. All of their location was obtained. No warrant. So Congress has to recognize that any thought that internal regulation is going to control the use of power by the FBI is going to fail.
Does that get back to the fox guard and the hen houses?
That's
you mentioned
correct.
Earlier?
Where are we vulnerable? Where do we still have problems? Where do you worry at night that we are going to lose our precious freedom? Mr. Tolman.
The first thing that comes to mind that you did well is you won the public debate on this issue. It was, you know, it used to be very siloed, limited voices that were shouting, this is a concern and it's going to violate citizens' rights and they're going to abuse it. And it was not believed and the public was not aware. This body, and I give this House the credit, not the Senate, I give this body, this chairman and others that turned the tide in the public debate on this and the awareness. And that to me is the battle. I would say the thing that keeps me up at night is this. I would like our FBI to get back to finding bank robbers and less intelligence gathering. And until that happens, we will always need robust guidelines to rein them in.
Do you have additional ideas that you would like us to consider?
With respect to 702, we have addressed them, but with the FBI, I think we have work to do. I think shifting their mission back to interdiction of drug and violent crime should be their central focus and not the gathering of intelligence. And until then, we will see abuses that we have to rein in.
Can you elaborate what problems this poses?
Well, first and foremost, if the internal guidelines to help prevent abuse become effective, the FBI's response is to not stop wanting to get that information. Instead, they've pushed it out to purchasing that information, and it's the tip of the iceberg. If they expand that program, there's no end to what they can get without a warrant. It serves us no deterrence. And deterrence is the predictability of being held accountable.
Well, that was my next question too, which was to the extent that you didn't think that it was sufficient, would that be an actual deterrent for other people seeking to violate FISA? And are there additional avenues that exist to hold the FBI accountable in lieu of that?
There really are no avenues. In fact, the ethics investigations that would be conducted are all handled in-house. And subsequently, in any Solicitor General or Office of Inspector General that would actually attempt to investigate it, they're limited in that they can't themselves bring any criminal action. So I would say there's no current deterrence.
How would we increase that deterrence?
Well, certainly not relying on the courts and a Washington, D.C. jury to actually administer, accountability.
Mr. Tolman, are you saying that Washington, D.C. doesn't have all the answers for the American people?
I think that's exactly right. And I think this is why Congress is so important right now. How we utilize that, where we would not allow those access to documents and data that might be violative. Perhaps there's a layer that could be put in there that would prevent investigators from actually looking at the data until they've satisfied those protocols.